Forget anything else. From a pure common sense point of view, I mean, if there is a match happening, should the referee be selected by one of the team? It's just basic common sense that in a democracy, in an electoral democracy, you can't have election commissioners who are selected by the ruling party. There is a very, very strong feeling in the country, which is not unfounded, that the election commissioners who have been appointed in this manner are failing to make sure that elections are happening in an unbiased manner and in a free and fair manner. When there are questions, when people raise questions, there are doubts in the minds of voters. The election watchdog is not supposed to come in a press conference and tell people all is well and believe me that all is well. What they're supposed to do is to put out proper, actual, objective facts. I myself filed an application under Rule 93(2) of the Conduct of Election Rules, which gives citizens the right to ask for this information. I filed the application in May 2024. Today we are sitting in January 2025. I have still not got that information. Now tell me, how are citizens supposed to believe the Chief Election Commissioner that all is well? It's possible. But unfortunately, what we've been seeing is that in many cases, the Supreme Court has just dragged its feet and it has not acted with the alacrity with which it should have acted.
Hello and a warm welcome to HW News Network, your one-stop show, truth be told, for some engaging and thought-provoking conversations. Chief Election Commissioner Rajiv Kumar's retirement in February has brought back into focus before the Supreme Court the need to fast-track a decision on the legality of a new law dealing with the appointment of the Chief Election Commissioners, which gives the central government a dominant role. Now, Justice Surikant, heading a 3-judge bench of Justices Dipankar Datta and KV Vishwanathan, highlighted that the test regarding the validity of the Chief Election Commissioner and other election commissioners' appointment conditions of service and term of office Act of 2023 would hinge on whether the court's authority to pronounce binding decisions under Article 141 of the Constitution can be circumvented or diluted by a law. So the big question is that if this is the real test between the court's opinion and the exercise of legislative powers, what can the Supreme Court do? Will the Supreme Court strike down the law on the appointment of the election commissioners and chief election commissioners, which was amended? All this and much more this evening with Anjali Bharadwaj, the renowned transparency activist who joins us. Thank you so much, Anjali, for joining. And I really want to know from you that is this the real test of the electoral democracy in the country? Because Rajiv Kumar is retiring on 18th February, and the very mentioning of this case has just happened, and now the next case is posted for hearing on 4th of February. What are you really expecting from the Supreme Court?
Well, Neelu, I think it's very clear that in any electoral democracy, the watchdog, the referee, who in our case is the Election Commission, must be independent. Under the Constitution, the Election Commission of India has been mandated to hold free and fair elections, to make sure that the electoral process is not vitiated in any way, and that when we go and cast our votes, the results are really what people wanted, and we get a government that we want. So in this situation, it's very clear that no political party in the fray who's fighting elections should be able to control the election commission, the election commissioners. The chief election commissioner, like you said, is going to retire in February, and there is a very big question mark today, because let's understand that the Constitution of India basically, while stating that the Election Commission must have the Chief Election Commissioner and the election commissioners, left the appointment process to be decided by law. The Constitution said that there must be a law by which independent election commissioners can be appointed. Now, in the absence of a law, the Constitution says that the executive could carry on that function. So, what really in the Constitution, what one can understand is that there was an expectation that sooner than later, a law would be put in place by which election commissioners will be appointed in an unbiased manner. Now, unfortunately, there was no law that was enacted. So we had, over since independence, we had a system where the executive, which is effectively the ruling party, was going on appointing election commissioners, the chief election commissioner. Now, by and large, in the country, there was a sense that, barring a few cases, that elections are free and fair. Unfortunately, over time, there was a problem. People started feeling, especially in the 2019 elections, there were many questions that came up about the conduct of the election commissioners. So a case reached the Supreme Court. There was a petition in the Supreme Court to say that the ruling party can't appoint election commissioners, because then they will appoint election commissioners that are pliant, and they will want their own people as election commissioners, which essentially means that the independence of election commission finishes. And in this matter, the Anup Berwal matter, as it is called, the Supreme Court gave a landmark judgment. There were hearings, there was very detailed discussions that took place, and in that, the court basically said that in a democracy, the election commissioners cannot be appointed by the ruling party, by the executive, because that goes against the very grain of independence autonomy. Because if the ruling party, which is actually forming the government, the executive, is deciding the referee, is deciding the election commissioner, then we have a problem on our hands in a democracy. And the court, basically, what the court said was that the selection committee of the election commissioners must not have a preponderance of the executive, of the government. It should not be a biased committee, so that an independent person can be chosen. And the court said that 3 people should appoint the election commissioners till an appropriate law is brought in. And the 3 people were the Prime Minister, the Leader of Opposition, and the Chief Justice of India. So all 3 of them, if they were to sit in a selection committee and they were to appoint, the hope was that an independent person can be brought in to do the job of the election commissioner. And of course, the court said that the Constitution gives the right to make a law to the parliament, and till the law comes, this is what the composition of the selection committee will be. Now, what we have seen is that the government immediately brought a bill to parliament, which was pushed through. It has become a law, in which the government has basically changed the composition of the selection committee from what the Supreme Court asked. The government has said that the Prime Minister, 1 minister, Union Cabinet Minister, and the Leader of Opposition will sit together. So this is a 2:1. There are 2 people from the government, and there is the Leader of Opposition. And unfortunately, it also goes on to say that if there is a vacancy in the selection committee, that somebody
No,
has
but actually the question is that even in the
even
past,
then it will be held. Sorry.
right? No, but in the past as well, when the former election commissioners were being appointed, Supreme Court was seen as dragging its feet, and they did not put a stay on the appointment, saying that it will lead to a lot of chaos, there'll be a lot of confusion because elections have been announced. So, given that attitude, do you think that they will be able to dilute this law, and especially the section which has been challenged, the section 7(1) of the statute which has been challenged? Do you think that Supreme Court really can strike this down?
Well, I think that the Supreme Court gave a very, very clear judgment in the Anu Berwal case, where, like I said, they did put together a selection committee till the law was made. But basically, what they said was that the selection committee should not have a preponderance of any one party. It should not have a preponderance of the government, the ruling party. And now, what has happened through the law is the exact opposite of that. The selection committee that has been made under the law is not in keeping with the letter and the spirit of the judgment that the Supreme Court had given. And therefore, I think that the challenge stands a very, very good chance, because the court went into very great detail before giving that judgment. So now what we are seeing happening is complete non-compliance. I would even go so far as to say it seems like a contempt of the Supreme Court judgment, because what the government is saying is that never mind what the court is saying, we will bring a law, we will pass a law, and we will do exactly what we want. Now, even from a pure common sense point of view, forget anything else. From a pure common sense point of view, I mean, if there is a match happening, should the referee be selected by one of the teams? That is exactly what the question is today. So, if the Supreme Court of India were to today hear this matter, first, it has already heard the matter and given the judgment. But now, in this particular case, when the law is being challenged, the Supreme Court simply has to, it's just basic common sense that in a democracy, in an electoral democracy, you can't have election commissioners who are selected by the ruling party. And I think that there is a very, very strong feeling in the country, which is not unfounded, that the election commissioners who have been appointed in this manner are failing to make sure that elections are happening in an unbiased manner and in a free and fair manner.
No,
So,
but if you, Anjali, I'm sorry to interrupt you at this point of time, but when you're saying this, Chief Election Commissioner Rajiv Kumar, while announcing the Delhi poll dates, he came up with a big clarification saying that, all these are merely doubts and doubts in the minds of the people. He's saying that what he said in Hindi was कि शक करने का इलाज तो किसी हकीम के पास भी नहीं है. This is what he said, that no doctor had the treatment if you are doubting and suspecting all the time. And he gave a long list of clarifications that, as far as the voter turnout data is there, we've given it all. We've not been wrong. As far as the names of the voters in the voters list is concerned, he says no deletions have happened. Then he tries to justify in his own way why the law was changed overnight as far as the Rule 93 is concerned in the election conduct rules, and he's saying it's almost like a breach of privacy when you come out with the footage of the polling booth inside. So all those clarifications he gave, justifying each and everything. So what can one really expect? Because Supreme Court again might just say that it's a constitutional authority, we will not get into it. So what is your feeling? That's how will Supreme Court really handle this issue now?
Neelu, everything that you've just said very clearly points to the fact that there have been many questions and doubts. So, like the Chief Election Commissioner himself said, that there were several doubts, और उन्होंने कहा कि शक की कोई दवाई नहीं है. But the reality is that in a democracy, this is not what is expected from a constitutional body. When there are questions, when people raise questions, there are doubts in the minds of voters. The election watchdog is not supposed to come in a press conference and tell people all is well and believe me that all is well. What they're supposed to do is to put out proper, actual, objective facts. Now, let me come to the points that you said he made. For example, he said that voter turnout data is all out there. Why are people questioning it? Why are there doubts? What can we do? Very simple, what the election commission could have done. The voter turnout data is not something which is difficult to access. It is written statutorily in Form 17C. Form 17C Part 1, that is filled by every presiding officer who's sitting at the polling booth, polling station, is filling a Form 17C at the end of the day, Part 1, in which they say how many people came to vote, how many actually voted, what the voter turnout was, and whether that matched with the number of people who pressed the EVM button. Now, what would you and I do as an election commissioner if we wanted to truly clear the air? We would simply put out Form 17C Part 1. Now, that has been the demand from day one. We and people across the country, I would say, have been going and filing applications saying, please give us Form 17C Part 1 of our constituency, or some people have asked for the state. The election commission is refusing to do that. I myself filed an application under Rule 93(2) of the Conduct of Election Rules, which gives citizens the right to ask for this information. I filed the application in May 2024. Today we are sitting in January 2025. I have still not got that information. Now tell me, how are citizens supposed to believe the Chief Election Commissioner that all is well? Why should, in a democracy, this is a very feudal way of thinking that, look, we are there, why do you have to worry? That's not how democracies work. In a democracy, the Supreme Court has upheld so many times the right of people to have information, to know. The Supreme Court, even in the electoral bonds matter, said that voters have a right to know. They have the right to information. Why should the Election Commission of India, when there are questions, when there are doubts, try to hide information? In fact, when information is hidden, it's not shared, doubts increase. So, what was said, for example, about the voter turnout. The day after Christmas, 26th of December, the Election Commission put out a huge data set where they said this is the voter turnout, etc., etc. These are the numbers. But if you try to click on it, it makes you first agree to the statement that this is not according to statutory figures. Now you tell me, what use is that data? When there are statutory figures available in Form 17C Part 1, why should the Election Commission, more than 6 months after elections were held, for the general elections were held for the country, not put out the statutory data? When there is so much doubt that he himself is acknowledging that there was, why should the Election Commission try to hide things? And what has the Election Commission done now? And I think that is the most damning thing. The Election Commission has gone ahead and agreed with the government, the central government, to change the conduct of election rules so that people cannot access all the election related records that they want.
No, but Anjali,
How?
yes, right. No, but during yesterday's hearing, Justice Surikant had said, that the court understands the importance of the matter, but important matters also require a good amount of time for hearing. Now, 18th February is the date when Rajiv Kumar retires. And you think that 4th February is the next hearing. So between February 4th and February 18th, would those number of days be enough for Supreme Court to arrive at a solid conclusion, or maybe striking down the law? Can they really do that?
Well, Neelu, I think that what we are also now understanding is that, unfortunately, there are cases that just languish in the Supreme Court. The electoral bonds case had such an important bearing on our elections. The then Chief Justice of India, Justice Gogoi, even said that this has grave consequences for India's democracy, but the court did not find the time to hear the matter for 7 long years. Now, unfortunately, I wish I could tell you that, yes, of course, it's possible. But unfortunately, what we've been seeing is that in many cases, the Supreme Court has just dragged its feet and it has not acted with the alacrity with which it should have acted. But to your question on is it possible, I would think that it is perfectly possible. This is a matter which goes to the heart of electoral democracy. We are talking about the appointment of the watchdog who holds elections in our country. We are talking about the referee who is supposed to be unbiased, their appointment. What can be more important today? This has to be one of the most important pressing matters that is in front of the Supreme Court. Now, the court is saying, yesterday the mentioning happened of this matter, and the lawyers who mentioned the matter said that it will take not more than 20 minutes for them to make the arguments because it's a fairly open and shut case according to them. Now, I would say that even if it's not 20 minutes, even if it's 20 hours, the Supreme Court can find the time. Your point was that the election commissioner, the chief, is retiring on the 18th of February, and this hearing is now scheduled to be held on the 4th of February. There will be 2 proper weeks. I think that is more than enough time if the Supreme Court is interested in hearing this matter and pronouncing its judgment. And I think what is very clear is that this government has really gone against the letter and the spirit of the Supreme Court's judgment. The Supreme Court itself had said that no one should be appointed by a selection committee that has a preponderance of the executive. And the government has gone right ahead and done the exact opposite. So
No,
it
but do
is
you think that Supreme Court will take this occasion as a moment where it will take on the executive, because Supreme Court already had pronounced an order in the Anup Baranwal case, and in fact Prashant Bhushan yesterday said that the issue stands covered by the Constitution bench judgment in Anup Baranwal, and therefore this particular mentioning will not take much time. So do you think that Supreme Court will actually clutch at this opportunity to show the government that, look, this is how we are independently giving orders and you are circumventing the orders? And which is why that maybe in just 1 or 2 hearings Supreme Court might just come out with a very, very stringent order.
Well, what will happen? Nobody can tell, only time will tell. But yes, it certainly should be that way, where the court clearly says that a law like this has no place in a democracy. And this law, which they have brought, in which now we'll have the prime minister and one of the cabinet ministers sitting with the leader of opposition and selecting the election commissioners, goes against the letter and spirit of the judgment that the Supreme Court had also given. So I think that the Supreme Court should hear this matter. The Supreme Court should immediately take action because there is an appointment that has to be now made. And this is a question of the sanctity of our election process. Let me just remind you, through the 2020, 19, and 24 elections, tremendous questions have arisen about the conduct of the election commission. There were cases where people filed complaints of different kinds, hate speech, other kinds of wrongdoings that were happening in elections in 2019. No action was being taken, or selective action was being taken rather. No action against the ruling party and immediate action against the opposition parties wherever there was a complaint by the election commission. So we saw the election commission playing a very, very biased role there. In fact,
Absolutely.
we are not saying it. One of the election commissioners at that time, Mr. Ashok Lavasa, actually quit because he said that my dissent notes are not even being taken on board. So, I mean, what was happening in the election commission was alarming. We again saw questions about the voter turnout in 2019. That's when the case was filed on voter turnout issue. Now, again, before the 2024 election, we saw selective action by the uh, election commission, where ruling parties was being handled with in a very different way. The complaints about them were being handled than they were about the opposition parties. Again, there were huge questions about the voter turnout. The election commission stopped putting the absolute voter turnout figures in the public domain. For God's sake, it's the most basic information that can be made available about elections. When we go out to vote, we should know how many people turned up to vote. The number was not being given, and there was a large percentage increase, abnormally large, which was being recorded. Now, this raises all sorts of questions on the integrity of the elections. And when people asked for the objective statutory information, which is kept in the Form 17C, the Election Commission just refused. It has not been giving it. And now the final nail in the coffin has been that the Election Commission has agreed with the central government, and they have changed the rule under which people were asking for information. So, in
True.
the Haryana case, where in the Haryana elections, when the matter of Form 17C and other things went up to this Punjab and Haryana High Court, the Punjab and Haryana High Court said that the rules are very clear. The conduct of election rules are very clear. Under Rule 93(2), you have to give information that people have a right to get. And the government went ahead and they've changed the rule itself. The government is saying we don't want to give you information under this rule. So now that the court is saying we have to give you, we'll change the rule. And under the Representation of People's Act, the government can make rules, but the safeguard in that act is that the government can't make rules without the Election Commission, without their consultation and permission. And these rules, when they've been changed, they start by saying that the central government is changing these rules in consultation with the Election Commission of India. Neelu, the question that arises is that I can understand that a party doesn't want us to have information. Why would the Election Commission of India not be interested in transparency in the electoral process? Why should the Election Commission of India go ahead with the central government and amend the rules so that our right to information, which has been upheld by the Supreme Court, is violated? Now, these are very big questions. And when the appointments of the election commissioners are made in this manner, basically where people in any case are feeling that it's very possible that because it's the preponderance of the ruling party who's selecting the election commissioners, they're selecting their own people. In this
Absolutely.
situation, when all of this happens, these doubts are raised, the election commissioner coming in a presser and reading out a lot of nice poetry and saying all is well is not going to help. We
Absolutely.
need information. If doubts have to be allayed, the election commissioner can't say that shak ka koi ilaj nahi hai. The election commissioner has to come out as an institution, as an independent watchdog. It has to come out and put every piece of information in front of people and let them convince themselves that yes, this is what the voter turnout was, and indeed what is happening is correct. If the election commissioner is hiding, the election commission is hiding things, it is just showing that something is horribly wrong, and
Absolutely.
more questions are going to be raised and more doubts are going to be raised.
My last question to you, Anjali, is that Justice Kant, towards the end, when he asked the councils to remind the court about the case on February 3rd, so that it can be taken up on 4th, he also mentioned it in a very light vein, and he said that this would be a case of legislative powers versus the court's opinion. This is what he said. Now, what does this sentence, according to you, mean? Are you really hopeful? Yes, all hopes on the Supreme Court, what they would do. But given the fact that the boundaries and the contours of this case is very, very clear, and that Justice Surikant has spelled it out very clearly, saying that it will be a case of legislative powers versus the court's opinion. Would the Supreme Court really take on the executive in this particular case? Or
I
you
think,
think that
Neelu,
the Supreme Court doesn't have an option but to take on?
I think, Neelu, what is very clear is that the legislative powers cannot go beyond the constitution. I mean, we have a constitution of India, we have a framework where the election commission of India is supposed to be acting in an unbiased, independent manner, supposed to be the interpretation by the Supreme Court was that it therefore requires an independent information commissioner who is appointed by a committee which is not have a preponderance of the executive or the ruling party. So, what the Supreme Court ruled in the Anup Berwal case was not something that was their opinion. They actually interpreted what is there in the Constitution. So now, when the legislative powers have been used and the government has brought in this law, and of course it has gone through Parliament, I think it will have to be weighed in that sense. And that is what the councils were trying to say yesterday, that when they said that this is just a open and shut case, it's a matter of 20 minutes for us to convince the judges. What I think they meant was that the court went into a lot of detail and interpreted the Constitution and said that it has to be an independent body that appoints the selection committee, that appoints the election commissioner. And therefore, going against that and bringing this kind of law is not just going against the Supreme Court's opinion. It is going against a very clear judgment of the Supreme Court, which was within the framework of the Constitution, which was basically saying that in an electoral democracy, the referee who's supposed to make sure that elections happen in a free and fair manner is not biased himself or herself. That the referee is not seen to be a person of one of the parties. So I think it's very, very important that this case be heard. And yes, you're right, it will be for the people of the country a very important case,
Absolutely.
and something by which they will see how the judiciary is playing its role in the democracy as well.
Absolutely. That's a very important point, and which is what leads me to ask you that is it going to be something like a trial by fire for the Supreme Court?
Well, it certainly is one of the very, very important issues to be agitated in front of the Supreme Court. The last time the matter came up in 2024, it was very close to the elections, because the government made the law just before the 2024 elections. When it was challenged and it was taken up for hearing, the court said that, look, at this time, if we do anything, whether it is a challenge to the people who've already been appointed or granting a stay on this law, it will cause chaos in the elections. So they said that we will refrain from giving any judgment, but now is the right time. The Chief Election Commissioner is due to retire. This is a very, very critical time. The Supreme Court has the option and the opportunity to be able to go into this matter. And yes, I believe there is enough time if they have the will.
Right. Thank you so much, Anjali, for joining on HW. Thank you very much.
Thank you.
Stay ahead with our cutting edge news app. Instantly access the latest shorts in just 1 minute and breaking news in just 50 words. Download now for a smarter, faster news experience.